Colorado law says there are 4 elements to a breach of contract claim that the plaintiff must prove: the existence of a contract, some substantial performance by the plaintiff, or a legal excuse for not performing, failure to perform the contract by the defendant, and resulting damages to the plaintiff. Element 1. The existence of a contract. The components to a valid contract are offer, acceptance, and consideration. These components mean that one of the parties made an offer that was accepted by another. This requires that the offer not be countered or rejected. It must be fully accepted. Consideration requires that both parties receive something of value out of the contract. In most cases, contracts can be written, oral, or both. In other words, not all contracts need to be written. Colorado law has approximately 24 types of contracts that fall under the statute of frauds, with the most common being sale of real estate, leases that last longer than a year, sale of goods for the price of $500 or more, prenuptial or postnuptial agreements, credit agreements, and any contract that cannot be performed within 1 year. Element 2. Some substantial performance by the plaintiff. The plaintiff must demonstrate that they substantially fulfilled their essential contract obligations. The court determines whether the defendant received the contract's benefits to determine whether the plaintiff substantially completed them. Having a skilled Denver business lawyer on your side will make it easier to gather and present concise evidence demonstrating the plaintiff's performance and the benefit to the defendant. Element 3. Failure to perform by the defendant. The plaintiff must demonstrate that the defendant failed to fulfill their essential contractual obligations to satisfy the third element. The limited circumstances under which defendants cannot function without being held liable are referred to as defenses. Element 4. Damages for the plaintiff. The plaintiff must demonstrate damage for the final element. Damages are any loss the plaintiff suffers as a result of the defendant's breach of the contract's promises. A plaintiff might be unlikely to prevail in a lawsuit unless there are some quantifiable damages, even if the contract was completely broken. Plaintiffs in Colorado can only seek damages that were the probable consequence of the defendant's breach of contract. According to Colorado law, a plaintiff's damages should put them in the same position they would have been in had the contract been completed. While a plaintiff may be able to demonstrate that the defendant broke the contract, they may not be able to quantify their losses, if any. The law in Colorado allows for the award of relatively insignificant damages in these circumstances. Plaintiffs in Colorado have the option of seeking specific performance as an alternative to monetary damages. The court will require the defendant to fulfill their contractual obligations through specific performance. Specific performance is an extraordinary remedy that is generally only used when monetary damages are insufficient to right the breach at issue.